Good morning. I'm David Meyer, the head of restructuring practice at Vincent & Elkins, and thank you all for joining us today, both here in the room and remotely. I'm joined today by my partners, George Howard and Lauren Kanzer. So what are we going to cover today? We're going to cover what we refer to as lender-on-lender, creditor-on-creditor violence, which really occurs in the context of various liability management transactions. And we'll do a couple of case studies as well as discuss a handful of what those transactions look like. First, we'll cover up-tier transactions with a focus on the Curtis Simmons case, which recently filed in the Southern District of Texas. We'll also focus on drop-down transactions with a case study on Revlon, which filed recently in the Southern District of New York and recently confirmed a plan. And we'll also focus on some of the items that both companies as well as creditors should be focused on in the response to some of these types of transactions. We're focused just on these two case studies today, given time constraints, but the cooperation agreements that have been entered into in the context of these situations, as well as some transaction takeaways from both the company perspective as well as the creditor perspective. And so with that, let's get started. I'll turn the floor over to my partner, George Howard, to lead us out.
All right, thanks, Dave. So just generally to kind of set the table here, what is a liability management transaction? I guess that's what we generally use, catch-all category, to describe really any transaction a company facing financial distress is going to use to try and address its capital structure. So that could include anything from, the typical like tender offers, debt exchanges, et cetera. But I would say more recently, particularly accelerated, during COVID and in 2020, you've started to see these drop-down transactions and up-tier transactions. The goal, can usually be to try to accomplish a couple of things. Usually, number one is generate additional liquidity for the business. Can also maybe reduce, in some cases, has reduced overall liability for the amount of debt on the company. And sometimes, can give the company a little more maturity runway. In other cases, sometimes in these transactions, the maturity runway has actually been shortened a little bit. The up tiers in particular that really started in earnest in 2020 have led to a lot of litigation in a number of different state and federal courts, and then spilled over into bankruptcy courts. And I think that's one of the reasons we thought it would be helpful to study and focus on CERTA today as part of this discussion, because CERTA is one where CERTA has, filed for bankruptcy. And so you kind of see how it went from, I'll call it a liability management transaction out of court via an up tier, the litigation that happened, and then how that's played out so far inside of a bankruptcy case. So everyone listening today gets kind of the full spectrum of how these things may play out in other situations. So Lauren, do you want to flip to the next slide here? So just high level, I covered this, I guess, mostly, but I think people have gotten very creative, companies and sponsors, figuring out the flexibility in their capital structure to address their issues, and the various tools and different transactions available to them. And so here we have briefly summarized on this slide for people, up tier transactions and drop down. So what's the difference? An up tier is really where you take an existing lender group that's secured, and a portion of that lender group makes itself senior to the other lenders in that group, hence the up tier, right? So they're moving ahead of other lenders in that specific tranche of debt. And some sort of high profile examples of CERTA, which we'll talk about today, Trimark, Board Riders, Incora, and there have been some others as well. Lauren, do you want to quickly just cover drop downs and what those are for purposes of the intro here?
Yeah, no. So a drop down transaction, slightly different, it tends to be moving assets, some subset of the company's assets. Many of these have involved IP out to an unrestricted subsidiary, and then financing off of that new collateral that has been moved. And this is usually also similar to an up-tier transaction. You're really used to generate liquidity. It may be used to pay down existing debt, but another type of liability management transaction that we'll get into.
I think the key theme with both of these types of transactions and others is how can a company, its sponsor to the extent applicable, its creditors, extend runway, extend liquidity, do that on an out-of-court basis. And that's the idea behind these options, as opposed to pursuing a potential in-court path, because it's viewed as preserving and maximizing value for all of the stakeholders, and the company working with various creditors to try to achieve that objective in the first instance.
So that's a perfect segue, Dave, I think, to this slide, which is that when you're thinking about an up-tier transaction in particular, whether you're a company, your sponsor, or lenders, there's a balancing that goes on, right? And it's really like the benefits you might be able to achieve from the transaction against the risks associated with it. And given the high degree of litigation we've seen so far, I think litigation risk is sort of front of mind when you're doing one of these. The expectation probably should be you are going to get sued at some point by the minority lenders left out. And then on top of that, reputational considerations, right? For people routinely doing this, what does that do to ability to raise capital in the future, right? What does that do to being able to join a lender group in the future, right? Like I just thinking holistically, not just about what you might achieve in a particular situation, but also longer term, how doing a number of these transactions might impact the overall sort of, I'll call it landscape, and ability to do other deals in other situations in the future. I think what's interesting and what surprised people a little bit about up tiers when they really started happening is the number of changes that could be made to the existing lending documents with just a bare majority of lenders authorizing those changes. So really what happens is as soon as you get over 50.1%, there are a number of things, restrictions, covenants, et cetera, that can be amended or removed from the lending documents with just that bare majority. And if done in the right way, it allows the company to, when otherwise you just kind of looked at the face of the document and thought, oh, there's a restriction on how much debt the company can have, or there's a restriction on, issuing additional liens or releasing collateral, that a number of those provisions, it turned out, could be modified with the just majority lender approval, and that's how these transactions are getting done. I think on the counterpoint there is I think minority lenders who objected have kind of said that was never the expectation when we entered into this deal, right? That a bare majority of lenders would go through these lending documents line by line and create something, a new structure, a new senior level of debt that was never really anticipated when we entered into this agreement. And I think at a high level, that's what these boil down to, although we'll get into a much more detailed discussion of some of the actual technical legal arguments being made. So Lauren, let's go ahead and go to the next slide. So here's just a list of select up-tier transactions that you can just see. I think we wanted to show the slide, show the amount of litigation, right? You had Murray Energy was an early one here. Ended up getting litigated inside of the Murray Energy bankruptcy case and ultimately led to a settlement. You have CERTA, which we'll talk about today, which is they'll call it ongoing litigation, really, I would describe it. You have Trimark, which was involved litigation in New York State Court for 2 years before a settlement was reached. You have Board Riders, which has been going on since 2020 and still technically going on today, although it sounds like a settlement has been reached subject to some conditions and a sale happening. You have TPC Group, which ended up in bankruptcy and had a fight about a prior up tier inside of a bankruptcy proceeding in 2022. You had Incora, which is active litigation, 2022 to present. And Mitel is also currently in active litigation. So you kind of see here a mix of, bankruptcy courts, state courts, and federal courts are being involved. And in all of these, there's some kind of litigation, and you can see from the timelines, right, pretty long. Not like it's being resolved overnight. Okay, CERTA. So CERTA, I would just set up the situation, right? LBO in 2012 starts to run into various business challenges, right? Lost some major distribution channels when Mattress Firm and Sears went bankrupt, had, increasing competition from other startup, mattress companies and such, really started to strain their liquidity. And then of course, COVID hit, right? So they had a large amount of debt, but you started to see, as they announced earnings, meaningful declines in their performance. They had various ratings downgrades. You saw the debt trading prices trade down pretty significantly into distressed levels. You can see their second lien debt traded all the way down into the 20s in March of 2020. And then you started to see, if you were watching any of the restructuring sort of news feeds, that the company engaged a financial advisor in 2020, and then I followed quickly by a report that, Majority Lender Group was working with a legal advisor. And then you had started to see some market rumors about different transactions, liability management transactions, including a potential drop-down transaction, being discussed among, the company and various lender groups. Here's a simple slide, just what their capital structure looked like before the up tier. So 2 tranches of debt, first lien, second lien, pretty standard, 1.8 in the first, 424 million in the second, $2.3 billion total with maturities, in 2023 and then 2024. Here's what they did with the up tier. So they added a brand new super priority tranche of $200 million, for which the company got $200 million of new money to finance their business. They had an exchange tranche of $875 million, where they exchanged new second out, but super priority debt. So behind the new money, right, but ahead of all the existing debt. And they had exchange ratios where they were able to capture, discounts on the first lien and second lien debt, a little bit higher than some of the trading prices we talked about on the earlier slide, but pretty significant discounts, particularly on the second lien term loans that got exchanged. Then they added a new sort of flexibility, to potentially add even third out debt, and some other flexibility in the document. So you can see then at the bottom, what does the post-transaction capital structure look like? Effectively, they got $200 million of new money, but also were able to deleverage by $200 million, approximately. Right, but the maturities got pulled forward, I'll call it a few months, right? Instead of having until November 23, when their first lien was going to mature, the maturity date was moved to August 23. So those are some of the trade-offs in terms of what they achieved with the transaction. Here are, at least at a high level, what they had to go and amend with majority lender approval in the lending documents to make this transaction work, right? So first they had a defined term that they had to modify. Then they had to authorize the agent to enter into a new intercredit agreement. They had to add this new provision, about when they shouldn't trigger mandatory prepayments. And then they removed a provision of the credit agreement that had previously designated the subordination of the first lien term loans as an event of default. So, you want to go to the next one? Yep. Here's the litigation, right? I mean, you can see it just set off a flurry of, advisors, people objecting, a lawsuit gets dismissed, another one gets filed, back and forth. Finally, where we are today is that CERTA, filed for bankruptcy in January of this year. They tried to pull, and I think successfully pulled, most of these disputes in front of the bankruptcy court, where it got, the bankruptcy court entered a recent order on that, but then it's on appeal, and that appeal remains pending today. And I think we'll talk a little bit about in a second how that potentially impacts CERTA's ability to confirm a Chapter 11 plan and get back out of bankruptcy. Here are the technical relearns. I'm definitely not going to read this slide to everybody, but people try to argue first that there's usually a no action clause in lending documents. So the minority lenders file the lawsuit, and the majority lenders say, no, there's a no action clause. You're not even allowed to file the lawsuit in the first instance. I think pretty roundly in all the decisions on up-tier transactions, not just CERTA, but others where there's been litigation and motion dismissed, this argument around you can't file the lawsuit because of the no action clause has been rejected by courts. So people even in some other up tiers tried to actually modify the no action clause with majority lender approval to say specifically that no one could sue related to the up tier transaction. And judges also have likewise said, I'm not going to enforce that and toss the lawsuit out. Open market. So this is really what a number of transactions have relied on to justify offering this opportunity to participate in the up tier to just a select group of lenders. Is that the loan document allowed the company to go do what's called an open market purchase. And so there's been ongoing fight in various court battles with different transactions about what open market really means. The pro rata sharing provisions, basically people are upset. The pro rata sharing provision generally says that, when you pay a lender or lenders back under the loan documents. Everybody has to get their pro rata share of that. And these up-tier transactions where only certain of the lenders are getting to exchange their debt or getting to participate in the new money tranche, people argue violates that pro rata sharing provision. I think in general, courts haven't really bought that argument to date, because they read the documents very carefully, closely, and technically. And if there is technically a way to structure the transaction that doesn't violate the pro rata sharing provision, that fits within contractual interpretation, then courts are letting it go forward. Good faith and fair dealing is sort of like an alternative to the breach of contract stuff, to basically saying, okay, well, maybe we don't technically win on the technical contractual argument, but this is still not the expectation anybody had for the deal, and so we should still win anyway and get damages. I think there's been a split of courts on whether that's a valid cause of action or not, and I think TBD going forward whether that's going to go. And I think even in CERTA, that's one of the issues that still did survive the motion for summary judgment that was recently ruled on by the bankruptcy judge and is still a live issue to be determined. So the bankruptcy case, basically the setup here, right, is that they filed bankruptcy with the support of the same lenders that participate in the up-tier transaction, right? And then they tried to pull all of the litigation out of state and federal court in front of the bankruptcy judge. And, are on a path to try and confirm a plan in May, I think, is the current timeline, even though some of this litigation remains pending and outstanding and on appeal of the Fifth Circuit.
And just to pause for one quick second, because make sure for the audience. The up-tier transaction was designed, of course, to provide that incremental liquidity, to try to provide some deleveraging, and ultimately, the company required an in-court restructuring anyway. So you're seeing that as the first step, which is probably intuitive that the bankruptcy was not part of the strategy of the up-tier, but just to make sure we spell that out, now you have a form in which the up-tier transaction occurred, and now we're in court where creditors' recoveries are impacted. And now how's that going to play out as opposed to in a state court where you're fighting over the legality of that transaction?
Yeah. And to get technical for a second, they actually, the company had to tee up two adversary proceedings to deal with it. The first was to tee up, a proceeding to try and stay the litigation that was going on amongst the lenders, right? The minority lenders had sued the majority lenders, and the automatic stay is not supposed to apply to non-debtors. And so they needed this first, I'll call it salvo, to make sure that litigation stopped so that the bankruptcy court could address the issues instead. They prevailed on that. And then the second was an adversary proceeding actually asking the judge to rule on the validity of the transaction. So procedurally, that's how they went about it, and it's really the second one that's still in active dispute, I would say, and on appeal. Here's some detail about exactly what they argued. This is sort of technical, but generally, to extend the protection of the automatic stay to a non-debtor, you have to show an identity of interest, effectively that by letting the lawsuit continue, you are effectively suing the company, even though maybe they're not named in the lawsuit. A lot of times people hang on the indemnification obligations between the third party who's being sued and the indemnification the company owes to that party, because effectively then a judgment against the third party ends up resulting in the company paying them by the indemnification obligation. I think that was part of the rationale here. And so, as I said, they got the litigation stayed and then moved into the bankruptcy court's purview.
And George, I think there's also just probably a strong desire by the bankruptcy court judge they want to reach resolution on all issues. And so this is also just, the ability to bring this litigation into the bankruptcy court and help resolve it, I think is also part of the driver here.
Yeah, definitely. So the transaction validity, we won't go over this, but I think what the slide is effectively saying is the arguments I went over in sort of the table format that were being made in the state and federal court litigation pre-bankruptcy effectively just got made in front of the bankruptcy judge. And I think key difference to my mind is that in all the pending litigation in state and federal court, the standards the courts were analyzing under to determine whether the lawsuit should go forward or not, we're at the motion to dismiss stage, where you take all reasonable inferences in favor of the plaintiff, right? And instead, in the context of this situation in front of the bankruptcy judge, and actually this is similar to how the bankruptcy judge in the TPC bankruptcy case handled similar litigation, is that the bankruptcy judges are determining this on a motion for summary judgment standard, where there's more briefing. You can decide something as a matter of law or contract interpretation without needing evidence effectively. A litigator would probably shoot me for describing it that way, but so there isn't as much of a, I'll call it, favoritism towards the plaintiff and making inferences in their favor here. It's a more, maybe more in-depth analysis of the issues. And so you can see here the bankruptcy judge, effectively ruled in favor of the company, but he did allow them to amend their complaint and go forward with their claim around good faith and fair dealing. And that's what remains open. Well, and the decision on sort of the other arguments is on appeal to the Fifth Circuit and pending. So here's the appeal. I spent a lot of time on sort of safari. I think the most interesting thing we wanted to make sure we covered, and Dave, maybe I'll let you speak to this first, is how is this pending appeal in the Fifth Circuit around these issues going to impact CERTA's plan to try and confirm their Chapter 11 plan while the appeal is still pending? Because the Fifth Circuit said we're not going to expedite our review or do this before the confirmation hearing is scheduled.
Yeah, it's an interesting question, and I'm one that I'm sure the parties are currently considering how they will move forward. But as we've noted here on the slide, and as you previewed, you've got a confirmation hearing set for May 15th. And for the audience's benefit, that's really hearing to consider the Chapter 11 plan that's been proposed by the company to pave a path for CERTA's ultimate exit from Chapter 11 in the first instance. And so there was an urging to have the appellate court hear that before that hearing takes place. And the Fifth Circuit declined to do so, but we'll take this up on appeal. So where does that leave the parties? As Lauren noted, the indemnity provision is a really important part of this entire dispute, because the company is required to indemnify the lenders, and the participating lenders and the non-participating lenders have litigation that the non-participating lenders wanted to have be in state court, remain in state court in the first instance. So I think there's a couple potential paths forward. One of the paths, we would expect the non-participating lenders to continue to object absent a settlement to confirmation. They'll make a number of different arguments. Assuming that the plan is confirmed, the parties will have a couple different choices. You could have the plan not go effective, and the company continue to sit in Chapter 11 to see how the dispute plays out in appeal. You could have the company emerge with the indemnity obligations assumed and see what happens on the back end. Or, in this dynamic, it's also possible the parties will continue or start or however they're progressing or not as part of settlement discussions to see if something can be reached between confirmation and parties taking the risk on that plan ultimately being confirmed, or effectiveness in the first instance. And so I think, oftentimes you see the parallel path of litigation on the one hand with, settlement on the other. It's possible the parties will pursue that route. Time will tell on that front, just as the circumstances evolve.
All right, Lauren, your show.
All right, I'll take on drop-down transactions. So as I kind of covered at the outset, this is often involves moving assets over to an unrestricted subsidiary and then obtaining new financing where that serves as the collateral for the new financing. And this really is, I think the first transaction really of this kind was J.Crew. And then there were a few subsequent transactions, which we'll touch on, including Revlon, which utilized a lot of the same provisions that J.Crew did to undertake this type of transaction. But this relies on having credit documents that are, fairly permissive, and has, investment baskets that don't have a cap on how much non-cash assets can be invested, that they can be transferred to non-loan parties, and that there aren't kind of leverage restrictions or other tests that have to be met once assets are moved, automatic lien release provisions, and in many of the instances, once the assets are moved, particularly because most of these transactions involve IP, there will be a lease back to the company to utilize that IP. And so also having credit agreements that kind of allow for all of that to take place. So kind of four transactions that we highlighted here. And I think the interesting thing to take away from this slide is just that all of these matters have been settled. They are not without litigation. In fact, all of them had litigation, but they did all eventually settle. And then I think the next, we're going to move on to the Revlon.
And just to touch on that slide, you see two of those scenarios back to the, now we're going to cover drop-down transactions and what was the end result. In J. Crew and in Revlon, the company needed a subsequent in-court restructuring. In PetSmart and in Travelport, no further in-court restructuring was ultimately required as part of those transactions and how they ultimately played themselves forward. So you see some examples here. I think we get good insight as to just in the public forum of how does this play out in an in-court restructuring. Then we'll talk about the Revlon here as well, just like we did Serta. But I think it's just for the audience's benefit, sort of we highlight 4 transactions. 2 ultimately still required an in-court process. 2 of these transactions ultimately were able to be achieved out of court, and the company was able to avoid an in-court restructuring as well as its creditors avoid that result.
So at the kind of outset before Revlon undertook the transactions that it did, it had about $3 billion of debt. This was largely related to an LBO that it did to purchase Estee Lauder. And so there was a $1.8 billion term loan at the top, a $400 million ABL, and then 2 series of notes that were about $950 million. That term loan, we'll call it 2016 term loan, had a maturity in 2023, but it was a springing maturity if the 2021 notes were not repaid. And the company started to experience some distress even before COVID in 2018 and 2019. And so in 2019, they undertook the drop-down transaction. As I mentioned, this was pretty similar to J. Crew. So they utilized sort of 2-step process to move the assets. There was an investment basket that allowed unlimited non-cash investment in non-guarantor restricted subs. So the assets were moved there first, and then those subs could invest in other non-guarantor subsidiaries in an unlimited amount if it was non-cash. So they moved IP assets to secure this new term loan that they got in 2019 for about $200 million. Unfortunately, they continued to experience liquidity pressures and weren't going to be able to repay the 2021 notes, and that would have accelerated the maturity on the term loan and the ABL. So they began talks with existing lenders under the 2016 term loan to do another drop-down transaction that was going to be more comprehensive and refinance the 2019 term loan and take out the 2021 notes. And so in order to do this, they were going to need to amend the credit agreement and needed majority lender consent to do that. A majority of the lenders, understood that the company was going to do this type of transaction, had already experienced this in the 2019 transaction, and so they signed a cooperation agreement to try to block the amendments that were necessary to the credit agreement. So the company and certain of the 2016 lenders who were going to participate in this new financing arranged for there to be a revolver added to the 2016 term loan. So this basically just increased the denominator of the commitments and allowed them to reduce the parties who had signed the cooperation agreement to below 50% and a majority of the lend, so they could not block this transaction from happening. And then in 2020, they did execute a second drop down, this time moving, pretty much all of the company's IP over to secure this new loan. And then they used that to refinance the 2019 term loan and repay the 2021 notes. After the transaction was completed, the lenders who did not get to participate sent a notice of default to the agent and directed the agent to commence a lawsuit against the company. And that lawsuit was eventually withdrawn. There's a whole other set of related litigation on Revlon around this mistaken payment. So Citigroup, who was the agent on the 2020 facility, accidentally sent $1 billion out to lenders and paid them. And so because of that, they dismissed their lawsuit. That litigation was ongoing and actually just concluded at the end of last year. The Second Circuit reversed a district court decision and found that the lenders needed to return the money to Citi. They all did that voluntarily, and then that case was dismissed. So unfortunately, Revlon was not able to, the transactions that they did out of court weren't sufficient to kind of address their liquidity needs and manage all of their liabilities. And they did file for Chapter 11 in June of last year in the Southern District of New York. And as part of that, the lenders who did not participate in the drop-down transaction and the 2020 financing filed an adversary proceeding against the company. And the company and the participating lenders argued that the claims that were being brought, which were largely around consent, transfer of the assets, were derivative causes of action. So they were held by the company and couldn't be asserted by the lenders unless they sought standing first. And the bankruptcy court sided with the company on this and did determine that these causes of action were derivative. And so eventually, I think as a result of that kind of decision, the parties decided to settle, and they reached a settlement, I believe it was in February of this year. And the dissenting lenders are receiving 18% of the reorganized company. The lenders who participated in the transaction are getting the other 82% of the equity. And the plan was confirmed this month and is expected to go effective next month. Dave, George, anything you want to add on that one?
I think on the derivative standing point, Lauren and I have talked about it a little bit. I think it's, at least to my mind, open question whether similar arguments like that are going to be able to be made around some of the up-tier transaction litigation. My personal view is probably not, because the up tiers really involve a dispute between the majority lenders and the minority lenders about what was permitted and what wasn't, and whether the pro rata sharing provisions were violated. And those are really causes of action belonging to the minority lenders against the majority lenders. I mean, companies have been named in the lawsuits, but haven't really been the full target of the up tiers per se, and certainly company themselves have not sought to challenge any of the up tiers because they're the ones doing them in the first instance. So I think that, you know, every situation is gonna be a little bit different. So I think good to be mindful of that derivative standing point, but I'm just not sure it's gonna carry over significantly into future litigation around up tier transactions. A little bit of a, maybe I'll be wrong about that, but I think that's how I think about it, having seen how the Revlon court talked about it.
Yeah, two comments. One probably beyond the scope of today's presentation, and one that just brings it back to, you know, all these types of transactions. The first being that I think, if anything, it's going to impact perhaps some of the litigation strategy, just that gets deployed as it relates to the company seeking affirmative relief from the bankruptcy court, or instead, like in Revlon, not taking those steps, and instead the creditors bringing the claims forward, and ultimately a decision that these are, you know, powers that a debtor has in bankruptcy to avoid these types of transactions absent a stakeholder obtaining standing. And there's steps a creditor has to go through to obtain standing in the first instance and get court authority to be able to do so. And the second, that I think for, you know, sponsors to consider in the context of exploring whether it's an up-tier transaction, or instead a drop-down transaction or something else, is there have been claims brought against sponsors in connection with the state court litigations that, if there's one theme that comes forward, none of those claims have advanced to actually be found to be valid, and those have been dismissed, notwithstanding extensive litigation that's continued, in those state court arenas, and in the two examples that we've highlighted here have been brought forward into bankruptcy court.
And one thing I will also add on the drop-down transactions is I think you'll notice that, since 2020, there haven't really been any major transactions like this, and they haven't been litigated. I think in reaction to this, a lot of, newer credit agreements have really tightened up these provisions. And so if you're dealing with a, more recent debt document, it's likely going to restrict this type of transaction. Whereas, if you sort of have an older vintage, you may still be able to do something like this.
Yeah, and I think we'll talk more about that maybe in what does this look like in the future, but I don't think you've seen as much tightening or fixing in credit documents to fully block up tiers across the board.
Yep.
And I think it's been a little bit more almost every new lending doc restricts these type of J-Crew drop-down transactions, but there seems to be, at least to date, a little more flexibility still in credit documents around up tiers.
But it's a good segue because there still are many sponsor-friendly or other credit agreements that sit out there that are older vintage and have not been amended for a variety of different reasons. And so that brings us to the cooperation agreement section, which I think we're really seeing an uptick in this and them occurring earlier in time as well. I think it's important for companies, sponsors, creditors to be aware of what those are and why they exist. So, what is a cooperation agreement? It's an agreement where the companies, lenders, or creditors will bind similar creditor parties in negotiations to achieve a desired outcome. It can involve a majority or minority of lenders. One of the key points I think here that you'll distinguish a cooperation agreement from what many folks will be aware as a restructuring support agreement is the company is not a party to this contract. This is instead an agreement among creditors to try to dissuade the majority and minority lender type dynamics that we've highlighted in some of the in-court litigation that's already occurred, where creditors are going to agree to work together. I think it's important for a company to be aware of a cooperation agreement among the lenders. If the lender group is disorganized, the company may be able to have conversations more quickly with some of those creditors. By the same token, if a cooperation agreement exists, it may impact the company's ability to negotiate with its creditors a desired out-of-court transaction in the first instance. From a creditor's perspective, I think there's different considerations to consider, of course, but it may be that entering into a cooperation agreement is a helpful tool to obtain negotiating leverage and also to avoid the risk of being left out in the first instance. Lenders will have to get an understanding of how their interests align with other lenders. And it can create leverage from a size perspective. It can create efficiencies among the group. And I think one just real key point to hear is these types of agreements are being entered into earlier and earlier in response to the transactions that we've just outlined and a fear that folks will be left out in the first instance. We've included on the slide here a number of examples of cooperation agreements. This is just a handful here. We talked about J-Crew previously. Revlon, there was a cooperation agreement among the 2016 term loans. In Wesco, Carvana recently, there's been in the news as it relates to the company's dynamics as it relates to trying to negotiate with parties that are party to a cooperation agreement. And we've also highlighted Brand Safeway as part of this, as another example. Again, these are a handful of I'll call it more public examples. We have seen and we will anticipate seeing many more of these types of arrangements entered into. In response to, there are still a number of documents that sit out there where there's significant flexibility for the company, and its lenders and creditors are assessing, how do I want to think about the risk or, frankly, my negotiating leverage as to working with the company, and if a larger set of creditors are working together, does that better influence their negotiating leverage? So that perhaps sounds great from the creditor's perspective, and from a company's perspective, how you're thinking about how quickly or not do I move in assessing my alternatives and liability management transactions, and how, frankly, I want to engage with my creditor groups. But one interesting example of those situations that we just outlined, those are all existing out of court in the first instance. J. Crew ultimately filed for Chapter 11, as we covered. But you're talking about out of court agreements among creditors. The company's not a party to those agreements. What happens if you have a cooperation agreement, and is there any sort of tales of the debtor now is in court, the debtor has exclusivity to propose a Chapter 11 plan? How might that play out in the essence of, again, the company's not a party to this agreement, its creditors are part of this agreement, or party to an agreement, and now the company's looking to advance a restructuring strategy. And I think the PWM property management case provides some interesting dynamics that folks should be aware of. And that's PWM owned commercial office towers in New York City and Chicago, and it commenced Chapter 11 cases in Delaware in October of 2021. And PWM was involved in extensive litigation with its property management agreement with SL Green Management. And SL Green Management was, or SLG, was a 49% preferred equity owner in the debtor. Rejection in bankruptcy is generally a business judgment test. And in this instance, this litigation spilled into the Chapter 11 process where you had both management agreement, equity ownership, significant litigation among the parties. So why are we highlighting it? And I think why is it most relevant here? The key creditors entered into a cooperation agreement that largely prevented those stakeholders from entering into plan negotiations with the company. The mezzanine lenders, including SGL, entered into a cooperation agreement, and they only agreed to support a plan of adjustment that would be prepared by that group. They were largely prohibited from considering, supporting, or discussing any other Chapter 11 plan. And again, why is that relevant? It's the debtor who has statutory authority, subject to it being terminated for cause, to propose a Chapter 11 plan for the first 120 days of a Chapter 11 case, and that can be extended for cause, and often is extended in large, complex Chapter 11 cases like PWM. And PWM noted this in its motion to extend exclusivity, and it came forward that they were asserting that there were violations of exclusivity because they did not have the ability to propose a Chapter 11 plan given, in their view, the restrictions that have been put in place under this cooperation agreement. And the creditors disagreed. They argued that they did not violate PWM's exclusivity because their plan of adjustment they put forward was filed under seal and only shared with the court. We'll see that happen from time to time in the context of creditors being unhappy with the dynamics associated with the restructuring and wanting to propose an alternative. And they only allowed the court, PWN, and the U.S. trustee for the District of Delaware to see that plan. They asserted that does not violate the debtor's the debtor's exclusive authority to file a plan because it was the company should be able to negotiate and understand where the creditors see the world based on their view and being able to see the proposed plan of adjustment in the first instance. And so I think that in this instance, the key point was, this was Judge Walrath, she found that cooperation agreements may, in some instances, constitute an improper solicitation in violation of the bankruptcy code. It's interesting that there have been similar rulings by this court in the context of post-petition restructuring support agreements as well, where the company is involved. The bankruptcy court extended the exclusivity that the company had, notwithstanding showing frustration with the progress that had been made in the case to date, but also noted that filing the plan of adjustment was not proper protection to protect the debtor's interests, and just sealing that in the first instance was not sufficient, largely on the basis that, I think in part, parties knowing that it's out there was key, but also just exclusivity so sacrosanct to a debtor's ability to propose its path forward in a Chapter 11 process. I think those are the key points on this front. Again, bringing this forward into a case where what's different than those other situations, this was a situation in which a cooperation agreement was entered into. There was no deal when the company filed for Chapter 11. You had significant litigation among the parties. You did not have any organization as related to a potential path forward and litigation over plan exclusivity in the first instance, and a judge that was very eager to try to push the cases forward towards some successful resolution. And I think those are some of the key points, though, to keep in mind when thinking about companies on the outside looking in, if you're a creditor from a cooperation perspective, balancing, how does that help my negotiating leverage on the one hand, but what are my risks if now I'm in an in-court process and the debtor is going to tell the bankruptcy court about its inability to propose a path forward given the dynamics with its stakeholders. Lauren, George, I don't know if there's anything you want to add, on that front.
I mean, I just say, cooperation agreements, I think, are like a relatively new phenomenon here, right? And so this is a very recent example of how it played out in a bankruptcy scenario, but I think there could very well be more arguments like this, or, different facts, different arguments around the validity of cooperation agreements. It used to be, right, you kind of form an ad hoc group of lenders, you all sort of gentleman's agreement, you're gonna work together, you'd hire a law firm to represent your ad hoc group, right? This idea that you're gonna sign a formal contractual agreement among the lenders that dictates how long you have to cooperate together, who among the parties signing the agreement can actually approve a deal or not, right? What threshold of the signatories can say yes to a deal? Like, can the others then who don't say yes get dragged along? Can they object, right? There's a lot of additional stuff in these cooperation agreements that sort of puts a lender, gives away maybe some lender rights. That said, if you don't sign one and a majority does, you're putting yourself at risk that they're gonna, with 50.1% of holders, right, do something and authorize, like, for example, an up-tier transaction, and you're gonna be left out, right? And you're gonna be behind a significant amount of new debt, or you're gonna have your lien stripped or covenant stripped, or whatever's permissible. And that's just gonna sort of, hit you in the head, right? You're not gonna know what's going on. You're not privy to the conversations. And your only, I think, remedies at that point are you could try and propose an alternative deal to the company that you think is better, assuming you have the capital to do that, right? Or you're gonna have to file a lawsuit, which could sit in state court for years, right, before there's an outcome. So I think it's led to a very interesting dynamic, and I think because of what I just described, you're seeing more and more people just go ahead and be like, well, I'd rather be on the inside, right, and be part of the cooperation agreement than be stuck on the outside. But, we'll see as these situations continue to play out. I think we're very early innings on this. What this really does to the dynamic, and what happens if some of these companies actually fall into a restructuring process, and whether you run into issues like came up in this PDOM management case.
I think it'll be also interesting to see, George, kind of if people really stick to the cooperation agreement, how effective are they in binding lender groups? And will people sort of break away if there's a deal that makes more sense for them? And what would be sort of the consequences of doing that?
Yeah, it's a great point, Lauren. Totally untested, right?
Yeah.
And then there's also, like, even, you saw it in Revlon, and it's happened in some of the up-tier transactions too, like just having a bare majority doesn't necessarily mean you're protected, right? Because sometimes there's flexibility to issue new debt securities and change the ratio of like who's supporting and who isn't, and who holds enough to authorize certain transactions. So just because you've signed a cooperation agreement, depending on how much debt there is and what the approval thresholds are for various items, doesn't necessarily mean you've protected yourself.
And to bring all of it back together, I don't know when it will happen, but it will happen in some deal out there. Someone will breach a cooperation agreement. There will be, more likely than not, some in-court process. Where does that creditor bring, or where creditors bring claims against that breaching creditor or not? Is it stuck in state court? Does it get brought into bankruptcy? Now, are we talking about indemnity claims? How are these items all going to come together? Because much like any agreements, there will be some party or parties out there, like you highlight, Lauren, that will breach at some point in time. And how does a company assess those various options as well will be, I think, an important part to consider. Want to finish this off?
Yeah, sure. Sorry, I think we've covered a lot of this, right? But just what are some key takeaways, right, of what's going on? And then we'll leave hopefully just a couple minutes if people have questions, right? But I think, people and companies and sponsors and lenders, are earlier and earlier taking action, right, or starting to assess their opportunities, because particularly when it comes to like these cooperation agreements, there's sort of an early mover advantage of like if you can get together that majority, then you have real leverage over the minority lenders who aren't part of your majority group, and you can offer potentially the company various transaction alternatives that maybe weren't available without majority lender support. I think we'll continue to see transactions be very bespoke depending on a situation, crafted depending on what the documents say and the company situation. And I think that means, coming back to the sort of early action, right? That being fully up to speed on a company's credit documents and where the potential flexibility or gaps or interpretive, provisions might be, can be really valuable to do that work much earlier than maybe folks otherwise used to do. There's going to be a lot more weighing, I think, of litigation risk, particularly when you're talking about an up-tier transaction. And what does that do to the company's liquidity profile, their options, their runway? I mean, how do you weigh that against the benefits of the transaction? So far, reputational harm doesn't feel like it's been a big factor. Like, people continue to do and consider these things, but people also continue to do regular deals and raise money for other portfolio companies, et cetera. And in fact, we're not really seeing yet, I think we said this a little bit earlier, the restrictions in lending documents completely blocking off up tiers, right? I mean, you could put in a lending document, it's 100% lender vote to subordinate this first lien debt to any other debt, right? And then you wouldn't be able to do an up tier effectively. Some situations people are doing that, but a lot of times you're still seeing a lot of flexibility. Or Lauren, do you want to describe the kind of like middle ground that it feels like?
Yeah, sure. So I think we've seen a few credit agreements that have involved, saying that 100% lender consent would be required to subordinate the existing lenders. But if you offer an up-tier transaction to all of the lenders, then only a majority consent is required. And so I think that's kind of the middle ground of trying to give the company some flexibility to do this type of transaction while treating everyone slightly more in a pro rata way that lenders would maybe be used to.
Which is actually interesting, I think, because Lauren and I were talking about a little bit about this. Like, in connection with DIP financing, like, these issues were actually kind of out there when you're talking about a roll-up. And like, what kind of lender consent did you need to do a roll-up or not? And I think the kind of like market practice had been, as long as you offered the roll-up opportunity to all the lenders, you were sort of safe in terms of the pro rata sharing provision. Is kind of where people landed. And the up tiers obviously take a more aggressive approach on that. If I can just do this with majority lender consent, but what Lauren just described, I think, kind of goes back to a little bit of I'll call it what the market practice was, at least within bankruptcies and talking about DIP financings and roll-ups. So I don't know if that'll stick and sort of end up being, how a lot of credit agreements get drafted, but it feels like, based on my experience at least, like a pretty fair resolution where it gives the company the flexibility still, but make sure all lenders at least have the opportunity to participate in the transaction, don't get just blocked out. I think, we'll see what happens to the overall macro environment, but to the extent more companies start filing for bankruptcy, I think we've already seen a willingness of bankruptcy courts to really jump in and resolve these issues on very fast timelines. As I said, it's taking years in state and federal court to try and resolve these issues, and bankruptcy courts are doing it in like, sometimes, I think in TPC, the bankruptcy judge ruled on it in the first 30 days of the case on a motion for summary judgment standard, because it was resolving the issue was key to the DIP financing. So the judge just said, file your briefs, I'll rule on it, and then depending on the outcome, I'll rule on the DIP financing. So anything else you guys would add in terms of?
The one thing I would hate here, I think it's really picked up in number one, but I think it's an important point, which is any of these types of out-of-court transactions are complicated and require significant negotiations with creditors between the company, the sponsor, equity holders, creditors that are participating, and perhaps creditors that are not participating. And the reason I say that is that if a company wants to explore a transaction like this, it needs time. And so it is not going to be a strategy to explore a transaction like this on the cusp of an event of default, for example. And so each of these transactions, while they have different features and different negotiations, they require mobilizing a significant component of the creditor group and early action to have that complex negotiation. And frankly, there's dynamics that exist along the way as well. But that's just one point that I think is really important to flesh out here, which is if there's a borrower that is on the cusp or even in default and wants to explore an out-of-court transaction, and those out-of-court transactions are to look something like this, it really needs time to be able to do that and early action. And so that's, I think, a key point that, just would make sure we highlight as part of a takeaway that's, I think, consistent with perhaps not a change in terms of companies being able to explore all options and taking early action, but definitely something that I would draw out here because these are complex negotiations.
Yeah, and frankly, I think we've seen situations where the company's forced to, right? Where lenders just proactively come to the board and say, hey, I think we can do an up-tier transaction. I think we can do a drop-down transaction. And this definitely maximizes value and consistent with your fiduciary duties. Like, you should do this, right? And so even if you don't want to, like, as a company, you might be confronted with this earlier than you might otherwise expect. I think particularly what's going on with the cooperation agreements and just the general market sort of trends around these types of transactions. We only have a couple minutes left, so
Take questions.
open it up to any questions people have.
You know what? It's a great question. And I think what I would really say is any sign of financial stress is you're seeing more and more discussions among creditors to say, particularly in privately held companies, is that a scenario in which we should consider a cooperation agreement being entered into? I don't think it is drawn on a particular sector or even a particular number of creditors. I think it really is just distinct on some of the, I'll call it sponsor-friendly forms, have more range of motion in them, and folks seeing these types of transactions and assessing, is this something we should work together on because we can all analyze the potential risks and opportunities we may face, and so are we better off working together? I think that's the most common thread you see just in terms of the situations where these types of agreements are being entered into.
Yeah, I totally agree with that. It seems like at the first whiff of trouble is when you start to see
And that could be years out.
Yeah, yeah, exactly.
It's
right?
not as if we see a liquidity issue in 6 months. You could have that too, I suppose. But we're really thinking about this being down the line. And that's why from a company's perspective too, back to George's point, if their creditors have an idea of what a transaction looks like, it may create increased pressure on the board, on the company, on management to consider that alternative if picking off and or doing some type of other amendment or liquidity injection is now foreclosed by what the agreement looks like. I should note that the terms on these cooperation agreements, they're not, generally speaking, indefinite. You may have some term because a lot of things could happen along the way. Is it a 3-month term? Is it a 6-month term? And can it be extended? Of course, things can be extended. That's just one other point I would draw out. Well, thank you again for everyone for participating here in the room today as well as remotely. It's been a pleasure presenting to you all, and thank you for joining.
Thanks.